Hello and welcome to In Depth. I'm Teena Jha. In 2013, the Supreme Court directed the Election Commission to include a NOTA option that grants citizens the right to not vote for any candidate contesting the elections. In January 2014, the none of the above option was also included in the Rajya Sabha elections. 4 years later, on 21st August 2018, the Supreme Court ruled that NOTA cannot be permitted in Rajya Sabha elections. And on 11 September this year, the Election Commission issued a notification ordering the removal of NOTA from Rajya Sabha and Legislative Council elections. Today in Depth, we'll try and understand the basis of the Supreme Court ruling in removing NOTA from the Rajya Sabha polls. What difference will it make in the elections, and how has NOTA fared in the 5 years of its existence? Before the NOTA option came into existence, people who cast negative votes were required to enter their names in a register and cast their vote on a separate paper ballot. Under Section 49O of the Conduct of Elections Rule 1961, a voter could enter his or her electoral serial number in Form 17A and cast a negative vote. The presiding officer would then put a remark in the form and get it signed by the voter. This was done to prevent fraud or misuse of votes. But this provision did not protect the identity of the voter. When the Supreme Court cleared the provision of NOTA in 2013, Section 49O stood annulled. NOTA protected the identity of a voter, keeping the concept of secret balloting intact. A Supreme Court directive led to the Election Commission of India withdrawing the provision of none of the above or NOTA option from elections to Rajya Sabha and Legislative Council in states. Now the option will only be available to the public during Lok Sabha and State Assembly elections. In a notification issued on 11 September 2018, the Election Commission ordered returning officers for Rajya Sabha and Legislative Council elections to ensure that the column of NOTA is not published in ballot papers. On 21st August, the Supreme Court ruled that NOTA will not be applicable as a ballot option in the Rajya Sabha polls, saying it was meant to be exercised by individual voters in direct elections. A bench of Chief Justice Deepak Mishra and Justices A.M. Khanwilkar and D.Y. Chandrachud observed that the introduction of NOTA in indirect elections may on first glance tempt the intellect, but on keen scrutiny it falls to the ground, for it completely ignores the role of an elector in such an election and destroys democratic values.
Brought to the notice of the Supreme Court that Election Commission had issued directions earlier that NOTA should be used for the elections of the Rajya Sabha MPs as well as MLCs of the legislative councils in the states. So when this was brought to the notice of the the Supreme Court, then they clarified that their original order of 2013 was only in respect of direct elections, whereas elections for the posts of Rajya Sabha MPs and MLCs, that is members of the legislative councils, are indirect elections. So that is what they have clarified, and they have struck down the notification issued by the Election Commission to order using of NOTA for these elections.
The CJI-led bench was in complete agreement with the 2013 Supreme Court judgment, which had ordered introduction of NOTA in direct elections. It said NOTA will destroy the concept of value of a vote and representation and encourage defection that shall open the doors for corruption, which is a malignant disorder. Writing the judgment, Chief Justice of India Deepak Mishra noted that the option of NOTA may serve as an elixir in direct elections, but in respect of the election to Council of States, which is different, it will not only undermine the purity of democracy, but also serve as the satin of defection and corruption.
Confrontation among parties was not there, but the Supreme Court has clarified that its original judgment of 2013 related to direct elections, and therefore they have said that it should not be used for indirect elections.
The challenge to NOTA in Rajya Sabha elections was brought to the Supreme Court by Gujarat Congress leader Shailesh Manubhai Parmar, on the eve of last year's elections involving Congress General Secretary Ahmed Patel. This after the party faced desertion of its MLAs and alleged poaching by the BJP. However, the BJP-led NDA government supported the petitioner in seeking to disband NOTA in Rajya Sabha polls that witnesses indirect elections. In Rajya Sabha elections, the MLAs have to show their ballot paper to an authorized party agent before putting it in ballot box. If any MLA defies the party directive and votes for someone else or uses NOTA option, he or she cannot be disqualified as a legislator. But the party is free to take disciplinary action, including expulsion. The defiant voter can continue to be an MLA and his or her vote can also not be invalidated for defying party directions. NOTA in Rajya Sabha polls was introduced in 2014, a year after the Supreme Court had ordered the Election Commission to give this option to voters in direct elections to register their protest that none of the candidates in the fray were suitable to represent them in Lok Sabha or assemblies. However, while directing the poll panel to strike down the NOTA option from Rajya Sabha polls, the Supreme Court held that the Election Commission went beyond the Apex Court's 2013 mandate in its ruling on NOTA given in People's Union for Civil Liberties judgment. The Supreme Court bench said the Commission cannot be allowed to conceive of certain concepts of ideas or, for that matter, think of a different dimension which would not fit into the legal framework.
Rajya Sabha elections, the voter has to reveal his identity already. He has to show his vote according to the present system. So it is the actual negative thing has happened right there because the secrecy of vote has been taken away. So that is not there. So if the secrecy of vote is not there, then taking away this right from him that he to reject all the candidates is meaningless actually. So because he anyway it didn't matter whom he voted. Today also if he doesn't want to show to anybody, he doesn't write serial number 1 and his vote will become invalid. So same thing like putting it right for NOTA.
The top court further stressed that democracy gains strength from citizens' trust in the purity, probity, integrity and rectitude of an electoral process. Such stronghold can be maintained only by ensuring that the process of elections remains unsullied and unpolluted, so that the citadel of democracy stands tall as an impregnable bulwark against unscrupulous forces. Bureau Report, Rajya Sabha TV. The Election Commission has introduced a specific symbol like other election symbols for NOTA option on electronic voting machines and also on the papers. The directive came in after the Supreme Court's verdict to provide NOTA option to voters. On 27 September 2013, the Supreme Court delivered a historic judgment according to which a voter could exercise the option of negative voting and reject all candidates as unworthy of being elected. The Apex Court directed the Election Commission to have an option of none of the above on the electronic voting machines and ballot papers in a major electoral reform. NOTA means none of the above. It simply means that if the voter does not like any of the candidates in the election, then he or she can dismiss all the candidates by pressing the NOTA or by putting a stamp in front of it.
NOTA basically, NOTA gives you a chance to reject every candidate. And this kind of provision was there even earlier in Indian election rules. There was a rule called Rule 49O. And that provided that if you went there inside the polling station and you were given the ballot paper and then you felt that you don't want to vote, then you could say I don't want to vote and return the ballot paper, sign on a paper just for record and come back. When EVM came, then also you could get identified and after that you say I don't want to vote for anybody, again sign some paper and come back. Or somebody who didn't want to reveal anything, he just would have gone when the ballot was there, would have gone inside, didn't mark the ballot and blank paper he brought in and put it inside the box. But machine came, there he could not do that. There he had to reveal his identity that he doesn't want to vote. And then some people said that look, the secrecy of vote means secrecy of not voting also. So therefore when you are putting him, making him sign some paper that he doesn't want to vote anybody, you are revealing his identity. And then the Supreme Court said, well, people have a right to say no to all candidates, and therefore let there be NOTA. So NOTA was implemented. But NOTA was implemented in both direct and indirect elections by the Election Commission. And that is how, about the indirect election, this latest Supreme Court order came.
The notion of providing the right to reject to a voter first came to the Election Commission in 2009. The Election Commission then informed the Apex Court that it wished to offer the voter a none of the above option on ballots. An NGO, the People's Union for Civil Liberties, filed a public interest litigation statement in support of this. During the hearing, the court decided to give the option of NOTA to voters in 2013. The Election Commission introduced NOTA option on ballot papers, displayed it on EVMs with effect from 11th October 2013. With this move, India became the 14th country to have the NOTA option. The Election Commission also clarified that NOTA votes will be counted but will be considered invalid and will not have any effect on election results. The NOTA button made its debut in the 2013 Assembly elections in 4 states: Chhattisgarh, Mizoram, Rajasthan and Madhya Pradesh, and Union Territory, Delhi. It constituted 1.85% of the total votes polled. The average NOTA vote share dropped to 0.95% in the 2014 Assembly elections held in 8 states. However, it increased to 2.02% in the 2015 Assembly elections held in Delhi and Bihar. Before the introduction of the NOTA, many political parties had opposed it, saying it will create confusion among voters. For example, the number of NOTA votes polled was larger than the winning margin in 261 Assembly constituencies which went to the polls since 2013 and in 24 constituencies in the Lok Sabha elections. One can argue that in these constituencies, the NOTA votes did make a difference to the election results. This leads to assumption that in the absence of this option, majority of NOTA voters would have preferred one or the other candidate in the fray. But in its verdict, the Supreme Court said that for democracy to survive, it is essential that the best available men should be chosen for proper governance of the country. It further added that by not allowing a person to cast a negative vote would defeat the very freedom of expression and the right to liberty. With inputs from Leena Sharma, Bureau Report, Rajya Sabha TV. With that, time for a very short break on the program. We'll be right back. Welcome back. You're watching In Depth. NOTA was introduced in India after the Supreme Court's verdict in 2013. And as we told you, it also made India the 14th country to institute negative voting. However, NOTA in India does not provide for a right to reject. The candidate with the maximum number of votes wins the election irrespective of the number of NOTA votes polled.
In 2013, the Supreme Court mandated that all national and state elections must offer a none of the above or NOTA option to voters. But after the introduction of NOTA, many started showing their dissent towards the option itself. The dominant argument being, what is the point in going to the booth, standing in a queue and at the end of it all, not voting for anyone at all? NOTA votes affect neither the validity of the election nor the winner. Even if NOTA were to receive a majority of the votes, the winner would be the candidate who received the most votes among the non-NOTA votes. It has been argued that NOTA is not the right to reject all candidates standing in the election, but instead the right to register a negative opinion. However, many describe NOTA as the maturing of India's democracy. They feel NOTA can encourage political parties to nominate better candidates. NOTA also ensures better participation from the voters. This is in opposition to NOTA being considered a waste of vote or a merely cosmetic vote. In actual terms, NOTA does not imply rejection. Even if more than 50% voters opt for NOTA, it will not affect the results.
Sometimes, if the voter feels that none of the candidates whose names are on the ballot paper is acceptable to him, then he has no way to communicate to those parties who have put up those candidates, or to communicate to those candidates who are contesting the elections that I do not like any one of you, I wouldn't like to elect any one of you. So by giving the NOTA option, the sentiments of those voters who do not find any of the candidates electable are made aware and communicated to all concerned. That is the first advantage. The second advantage and direct advantage is that this gives a message to the political parties that they should set up candidates who will be acceptable to the people, to the voters, and they should therefore be careful in the selection of their candidates.
Meanwhile, there is another option called as the right to recall or RTR that exists at local level bodies in many states of India. Under the right to recall, the electorate has the power to remove the elected officials before the expiry of their usual term. Thus, recall confers on the electorate the power to actually de-elect their representatives from the legislature through a direct vote initiated when a minimum number of voters registered in the electoral roll sign a petition to recall. This right has been debated and highlighted in Indian politics, but nothing was done.
Like political parties, when they think that they are not going to get vote, they have not been able to fulfill their promises, then in that case they can say, okay, then the other guy is also not so good, so okay, you can go for NOTA. So that is the kind of thing which can change the electoral scenario on the ground. So that is one negative that can come out of it.
In a democracy, a citizen should be allowed to cast his vote as he or she wants to, but at the same time should not be compelled to do so. Introducing NOTA by Supreme Court may be called a great reform, but it can achieve its objective only if it is seen as the right to reject and not only as a negative vote. Bureau Report, Rajya Sabha TV.
Until a few years ago, if voters did not find any of the candidates capable enough, they would not vote at all. And in this way, they were deprived of their right to vote. But now the voters have the option of NOTA or none of the above, and many of them also use this option even while casting their votes. Apart from India, which are the other countries that allow their voters to use the NOTA option? Let's find out in this report.
None of the above or NOTA ballot option can be used by citizens while casting their vote. The idea originated in 1976 during the Isla Vista Municipal Advisory Council elections in California in the US. Other countries gradually implemented this option in their countries. NOTA is in use in many countries that have a provision for victory with more than 50% votes cast. In a situation where over 50% NOTA votes are cast, the election is cancelled and held again. It is in force in Colombia, Ukraine, Brazil, Bangladesh, Finland, Spain, Sweden, Chile, France, Belgium and Greece. The value of NOTA option significantly increases in such a scenario. In Russia, this option was available for voters till 2006, after which it was removed.
In the unlikely event of NOTA getting the highest number of votes, it is not very clear as to how the electoral authorities should proceed, because in India it has not happened, but if it happens, then there is no other option but to cancel the election and order re-election. So that is again something that is not really very desirable. But in some countries they have found the alternative that the person who gets the second highest number of votes, in case the highest number of votes are polled in favor of NOTA, the second highest candidate gets elected.
Different names are used for the NOTA option. In India, NOTA means none of the above. In the United States, it is none of these candidates. In Ukraine, it means against all. And in Spain, it is blank ballot. Till 2006, when this option was valid in Russia, it meant against all.
There have been cases, in fact, way back in 1976, I am told, the Nevada state in United States of America, they tried something like this. The major one that is talked about mostly is 1990 when USSR election took place. Soviet Union election took place, and there were about 200 candidates. There were seats, and there were re-election in a large number of seats, and the result you all know. So, so in many countries it has been used.
There are several countries which are currently using this NOTA option, which is called by different names. I mean, not everywhere it is not none of the above. None of the above is not the only way. Somewhere it is called a white vote, somewhere it is called something else, but it is in use in countries like Bulgaria, in Colombia, in Russia, and in Ukraine, in Bangladesh, in Pakistan, and so on and so forth.
Many countries where NOTA is not in use are also contemplating to initiate this option. NOTA allows voters to choose candidates of their choice or not choose at all. The NOTA option in India has given right to people to exercise their franchise who could not vote because of the absence of the candidate of their choice from the electoral list. Bureau Report, Rajya Sabha TV.
And that's it from us in today's edition of In Depth. We'll be back same time tomorrow with a comprehensive view on some other subject. You can also watch our episodes online on YouTube and Twitter and get back to us with your feedback and suggestions. Thanks for your time.